Did you know that if your medical expert is not available on the day that you promised the judge he'd be coming in to testify, it is possible that the judge could dismiss and throw out your case? Or there may be another alternative. You want to know what it is? Come join me on this walk through the neighborhood as I tell you exactly what it is. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, so let's say you brought a lawsuit against your doctor claiming that he was careless and that his carelessness caused you harm and injury. And now your doctor denies all of your allegations. So now your case goes through the entire litigation process, and it takes you 2 full years for you to go from start to the point where now your case is ready for trial. Okay, so now as your case is ready for trial, the judge, before starting the trial, wants to talk to the attorneys. Why? To talk about scheduling. Okay, counselors, tell me about scheduling. Tell me about how many witnesses each of you have. Tell me how long you think this trial will last. Tell me which witnesses are going to be testifying on which days. Now, why does the judge want to know this? The judge wants to know this for a number of reasons. The judge controls everything that happens during the course of your trial in the courtroom. The judge decides on scheduling. The judge has to decide when to start the trial, when to go ahead and start each morning, when to break for lunch, when to come back from lunch, when to continue, when to stop for the day, things like that. The judge is also responsible for making any rulings of law. You should know that the judge is responsible for many other cases besides yours. The judge may say, listen, on Wednesday morning there will be no court because I have to go ahead and deal with those other cases I'm handling. And now, if I'm planning on bringing an expert on a Wednesday, it may not be an ideal time. Why? Because my expert will not have enough time to go ahead and testify, and there won't be enough time for my opponent to go ahead and cross-examine him. So now we have to schedule our experts on days that we do have sufficient amounts of time. So now let's get back to the title of this video. What if I tell the judge, okay judge, my expert is coming in on Tuesday. And now the judge says, fine, your expert is coming in on Tuesday. He turns to the defense and says, okay, when is your expert coming in? And the defense says, okay judge, my expert will be available on Friday. Okay, fine. So now we know that we have testimony and witnesses throughout the entire week. Excellent. What happens now during the course of trial if all of a sudden my expert tells me, listen, I can't come in and testify on Tuesday because I now have surgery, emergency surgery I have to deal with? What happens then? I immediately have to notify my opponent that there's a scheduling problem. I immediately have to notify the judge as well. And I have to give a good, reasonable explanation about why this expert can no longer come in on the day that I promised the judge to do that. The judge has a number of options at this point. He can go ahead and accommodate the attorneys and our scheduling. Why? Because we don't often have control over when our witnesses are available. We often don't have control about who's going to come in and testify on what particular day. Sometimes there are things that are out of our control, and the judge most of the time understands that. But the judge could also turn around and say, listen, counselor, I gave you every opportunity to set up the schedule. I locked everybody in. You're putting me at a disadvantage and you're putting the defense at a significant disadvantage. And because of that, if you don't have an expert on Tuesday, now you've got a problem. Now what does that mean? It means that if I can't put on a medical expert to testify, guess what? Then I can't go forward and get this case in front of the jury to give us a verdict. Why? Because we are required to have a medical expert confirm each one of the claims that we are bringing in this case. That the doctor was careless, that he violated the basic standards of medical care, that carelessness was a cause of your injury, and that your injuries are significant and permanent, And now, if I don't have an expert, or the judge is now refusing to allow me to put on an expert because of some scheduling problem, now I've got an issue. Now you might say, wait a second, that's not fair. Just because one doctor has a scheduling issue and has an emergency he has to deal with, you're telling me that that's going to prevent you from bringing on this case and the case will get dismissed before it even gets to the jury? The answer is yes, that could happen, which means we would have to appeal that issue. And you know what would likely happen? What would likely happen if we appealed is the appellate court, the higher court, would likely turn around and say, you know what? That is fully within the judge's discretion. The trial judge has a great deal of discretion on what he can and cannot do. Scheduling falls within the realm of exactly what he can do. So if he determines that you've been delaying things and it's all your fault that now things got delayed tremendously, and now he's so upset and angry because everything got screwed up because of your delays, and now you failed to notify everybody in a timely fashion, now the judge is taking his wrath out on you, guess what? It's highly unlikely that the appellate court is going to feel any sympathy and reverse that decision. The judge could turn around to the defense attorney and say, okay, defense counsel, is there any chance you could bring in your medical expert? I will take him out of turn and allow him to testify on Tuesday. Could we do that? And now the judge is exploring different options. Why? Because he wants to keep the testimony flowing. He wants to keep this case moving. He wants to keep the jurors engaged, and he doesn't want to have to delay having them listen to all the testimony and the evidence because one expert is not available. So that is an option that the judge has. Why do I bring this up with you? I bring this up because this does happen more often than not. And you don't hear anybody talk about this when they tell you about what happens in a medical malpractice case or in an accident case or in a wrongful death case. Now, I realize you're likely watching this because you're enjoying the scenery. No. I realize you're watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.